Welcome everyone to the Federal Bar Association Key sections, the rounds, FCA news with Tejinder Singh. The rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald, chair of the Key section with Tejinder Singh, who is a partner at Goldstein and Russell. And today, Tejinder, we are doing a hot off the press edition of the rounds with Tejinder Singh because just yesterday, Senators Grassley and Senator Leahy announced a new bill that they are introducing in the Senate to amend the Federal False Claims Act. What's this all about?
Yeah, so there has been discussion for some time now about whether the False Claims Act needs to be amended to deal with some of the confusion that's come up after the Supreme Court's Escobar decision and with some other issues that have been bubbling away in the lower courts, some of which we've talked about on this show already. The proposed amendments are designed, I think, to address a few of those topics. They've got an amendment about materiality, an amendment about discovery on the government, one about the government's dismissal authority, and then one about former employees and their protection from retaliation. And so there's a suite of small amendments to the statute that are designed to address these ongoing issues.
So let's take the last one first, because we've dealt with this before in a previous version of the rounds. This is the issue of whether Section 3730H applies to former employees. Where are the courts on this, and what does this legislation, how is it designed to address this issue?
So there is a relatively new split about this question. As we talked about on the show before, the majority view throughout the courts was that this doesn't apply to former employees, but then one court of appeals took the opposite position just recently, and it now appears that the Senate wants to side with that court, the minority view, and say, yes, it protects former employees as well, which is a positive development from the relator side.
So how is this constructed in terms of the language of this provision? And like when you looked at it, what was your reaction?
Oh, it couldn't be simpler. They just add the word "or former" to the statute. And so it's, any current or former employee has been dealt with. And so the question that I think remains is the statute prohibits discrimination in the terms and conditions of employment. And so the addition of this language makes it clear it applies to former employees, but it may still be limited to the terms and conditions of their employment. So for example, what I think a lot of people are really concerned about after they leave their jobs, having blown a whistle, is are they going to be blacklisted in their industry by their former employer? And you would have to have a debate about whether getting a positive reference or a negative reference or being defamed otherwise counts as discrimination in a term of condition or employment. I don't think this amendment necessarily changes that. On the other hand, it's quite clear that Congress is trying to protect these people. And I think courts would feel some pressure to interpret the statute that way. And I think that naturally you could see terms and conditions of employment, meaning not just your old job, but the terms and conditions of your new jobs. And so if you're being harassed vis-a-vis your new job, you could make a pretty good argument that the statute applies.
Let's just use an example. I mean, certainly it would apply to a poor job reference, it seems. But what about, let's say, defamation outside that context, maybe at a conference, right, where the old employer and the new employer kind of are talking, and the old employer says something, defamatory about the whistleblower? Would that be covered?
Well, I mean, so let's ask the question, I guess, the other way. If an employer was saying something bad about their current employees at a conference, would that be covered under the prior version of the statute? I think probably, right? And so if the only addition the amendment makes is to add the phrase, or former, then again, probably. I think it would be the type of thing that would have to be hashed out a little bit just to see if that kind of talk is really about terms and conditions of employment. Maybe it would depend on whether the person on the receiving end of the defamatory information is in the potential to influence the relator's job prospects in some way. But I think that, it would be a case-by-case thing.
So there are some other provisions in the proposed legislation. One dealing with this issue of seeking discovery from the government. What's that all about?
Yeah. So defendants have sought discovery from the government after the Escobar decision into materiality. They've basically said, give us all the information you have about every time you've ever dealt with anything even vaguely like this case, so that we can figure out how you've reacted to those and show that you don't really care about these violations. And in some cases, the burden of that discovery has prompted the government to move to dismiss a relator's case rather than responding to the discovery. And defendants have not missed that fact. So they have started issuing more discovery requests in a hope of prompting more dismissal requests. What the proposed amendment does is it says that if the government wins its fight, that the discovery sought is not relevant, not proportionate, or unduly burdensome, then the defendant also has to pay the government's costs for responding to the discovery request. Now, I don't know how much these costs would be. We're really talking about attorney's fees and time for dealing with a discovery fight. The hope, I think, is that it will temper defendants' enthusiasm to make these overbroad requests and send a message to the lower courts that they need to look a little harder at these. But that's the mechanism that Congress is using.
There's also another provision on materiality, right? How does that work?
Yeah, the materiality amendment is an interesting one. So it's a two-part thing about materiality. So to set the table, and the statements around the legislation make it really clear exactly what the Congress is trying to do. Congress is upset that in the Escobar decision, the Supreme Court said you can find no materiality when the government continues to make payments with knowledge of the violations. What's happened after that is in the lower courts, defendants have always said, well, the government kept paying the claims. And a lot of lower courts have thrown out cases with pretty blatant fraud, saying, okay, well, it's not material under Escobar. So this amendment is supposed to try to fix that. The way that they've tried to do it is they say the relator can prove materiality by a preponderance of evidence. And a defendant can rebut an argument of materiality under using clear and convincing evidence. So it appears they've imposed a higher burden on the defendant than on the plaintiff. It's not 100% clear to me how this works or how this addresses the Escobar problem, because let's just assume a hypothetical example where the defendant can prove immateriality by a preponderance of the evidence, but not by clear and convincing evidence. You would think, okay, well, the way this is written, it seems like the defendant should lose, right? But why wouldn't the defendant be able to get up and say, well, if we've proved immateriality by a preponderance of the evidence, it means that you, the relator, have failed to carry your burden of proving it by a preponderance of the evidence. And so we win. I don't even understand exactly how this burden shifting is meant to work. Normally, when you have burden shifting, like in the employment context, what the plaintiff has to do is make out a prima facie case, right? Something well short of a preponderance of the evidence. And then the burden is on the defendant to rebut it. But that's not how this works. Really, the plaintiff is required to carry out their full burden of proof, and then the defendant gets to rebut it. But that's already happened at the plaintiff's burden. So it's a curious one to me. But the legislative history is extremely clear about the problem they're trying to solve. And so I guess maybe there's a hope that the courts will take the hint.
And actually look at the legislative history.
Yeah, I mean, it's out of favor to do so these days, but some courts still do it. And when it's this explicit, maybe they'll do it.
The last provision deals with the government's ability to dismiss a qui tam and the standard that they have to meet and how they meet it. How does this provision work?
So right now, the statute provides that the government can move to dismiss a case under section 3730 C2A as long as the relator gets a hearing. But it doesn't say anything about what gets talked about at the hearing. And so there's been an open question about, like, what is this hearing for? What is the standard of proof to which anyone would be held, and what does a court decide? The government has previously taken the position that the hearing is just so that we can tell you that we're dismissing the case. And this amendment to the statute takes a different view. It says, well, no, at the hearing, the government has to provide reasons for dismissal, and the relator can show that they are fraudulent, arbitrary and capricious, or contrary to law. Really, probably the media standard there is arbitrary and capricious, because anything that is fraudulent or contrary to law would also be arbitrary and capricious. And so you've got effectively review under the Administrative Procedure Act standard of government dismissal decisions. This is meatier than the due process standard that the Ninth Circuit adopted in its Sequoia Orange case. So it gives relators a little bit more protection than I think they have in the status quo, but not a ton more. So the government still will get a lot of deference in these decisions, but they'll have to explain their reasoning in a hearing before a judge.
And they haven't always done that in the cases where they've sought dismissal.
No, they haven't. Or they've sometimes been extremely vague, right? They just say, well, we just decided the juice wasn't worth the squeeze or something like that. And then, they leave it at that without really getting into any detail. I think for relators, having the opportunity to probe those justifications is pretty valuable.
Tejinder, thank you. And thanks to each of you for joining us for this edition of the Rounds FCA News with Tejinder Singh. I'm Scott Oswald. We'll see you next time.